Yes, good evening to everybody. Welcome to the class. That is the family law that I am dealing the Muslim law, and yesterday that I completed the Indian Christian Marriage Act, and today that I am going to deal the Indian Divorce Act. So let us before I go further, let me know that what you have seen on the screen. See, read and tell me.
Good evening, Professor Dr. Mohammed S. Hussain.
Yes, what they are doing?
They are fighting, sir. Wife and husband.
Fighting. They are fighting.
Fighting means they are
Exchanging the hard words to each other, squabbling, or they are quarreling. Is it done?
quarreling. Yes, sir.
Not fighting. Fighting means using the hands and legs. It's called fighting. That squabble is the word is there. Even that also they can say arguing. I think the
Arguing.
squabble, SQABBL is squabble. I don't know what it meaning. Let us see squabble. A squabble in the sense a Nazi quarrel about something trivial. Family squabbles. Nazi quarrel and about something trivial. It's called squabble. How do you pronounce? Squabble. Squabble. That is the way of pronunciation. That is the family squabbles. So here they are quarreling each other, squabbling, and exchanging the hard words with the emotions with a high sound. So that is called squabble. Okay, now let us go to the Indian Divorce Act 1869. So the Indian Divorce Act 1869 is one of the few codified Indian personal laws governing Christians. See, here say personal laws, he said, because Christianity also a personal law, Muslim law also a personal law, and not signed. Okay. Then we'll see that. Because I'm saying that he did not sign. I have to admit him. Okay. No. Lakshman Rasa, you are welcome, Dr. Lakshman Rasa. So now it is the act contains the provisions defining the power of courts, grounds for the dissolution of marriages, nullity degrees, custody issues, etc. So what this act deals about? This divorce act is important as it affects the Christian community. It is specially made for the Christian community. Sir, whatever the Muslims, sir, the Muslim personal law is there, and Sharia law is there. So what about the Hindus? Whatever the Hindus, there is a specific act is there. Is it or not?
Dissolution of.
Of course, for that is a dissolution of a Muslim marriage act is there, and a Hindu marriage act also there, where the dissolution also comes, divorce also comes. So this act contains, especially for the Christians, defining the power of the courts, which court is having the jurisdiction to entertain such a case. Generally, first-class magistrate court having the jurisdiction to entertain such a case. So that is the Rishita, why? Because he is not signed. They are waiting in the queue. No. Okay. Now let us see. Yeah. So now Indian Divorce Act in 1869, according to the preamble of this act, it amends the law relating to the divorce of people professing Christianity. It even confers upon certain courts the jurisdiction to settle these matters. So the preamble of the act means first key of the word act says it amends the law relating to the divorce of people professing Christianity. Those who are professing Christianity, even though not born in the Christian family.
Sir,
Yes.
Sai Rishita is waiting, sir. Join her, sir.
Oh, then I could not hear, see the sign because here there is no, now it is there, is waiting, admit. Then I admitted. Yeah. Because previously it was not there because you comes late, they used to come. But now I don't know. It is asking for the admission. Okay, no matter. Admitted. So now, according to the preamble, it amends the law relating the divorce of people professing Christianity. The person, those who professing Christianity, also entitled for the Indian Divorce Act, Even the people those professing also they use this Indian Divorce Act. Even if confers upon certain courts of jurisdiction to settle these events. Now I will ask you one question. I would like to see that whether he could in a position to give the reply or not. See, here Indian Divorce Act is there. It is 1869, but when you see the Special Marriage Act is a 1954. When you see the Hindu, what I say, other thing, that is Muslim Dissolution of Marriage Act of 1939, if I not be mistaken. So these are all 19 are there. Why this is 1869? Can you give me the answer?
Because of British, they are first enacted this law before independence.
The Britishers are Christians.
British are Christians.
That is the reason they say the Christianity is more over there, and hence they are also Christian. Those who are professing also the Christian. So better you will make the law of this Indian Divorce Act 1869. So it even confers upon certain courts of jurisdiction, because all the courts will not give it. Certain courts will have their jurisdiction to entertain. But they say that it clearly says first class judicial magistrate only having the competency to deal these family issues. Okay. This is the only codified law regulating the divorces amongst the Christians. So the British had first enacted this law before independence, and it continues to be forced today. So that is the Britishers, they are the Christians. They enacted this law very beginning so that there will be, still it is continued. Yes, the act came into existence on April 1st, April 1969. Sorry, 1869. It applies to the whole country except the state of Jammu and Kashmir at the time. And furthermore, it applies only to those people who profess the Christian religion. Those who profess the Christian religion, for them it will be applicable over there. And then the parties must also reside in India to apply for any remedy under this act. So, number one, there should be professing Christian religion. Number two, the party should be residing in the jurisdiction of India. So it will not be applicable to the Jammu and Kashmir, because Jammu and Kashmir, majority of the people are, yes,
Hindus, sir.
yes,
Hindus
no.
are
In Jammu and
Muslims.
Kashmir, the majority people are the Muslims. Only few
Muslim.
people are the Hindus, and that's why it is having a special status because of the constitution. It's given over there. Of course, Article 370. Now it is no more in use. But let us see that, especially because it is a princely state at the time. Of course, here they obliged, because Nizam also obliged, and they have the Union of India has taken away the Nizam's property. So now there is a special status is given over there. So that's why it is not applicable to the Jammu and Kashmir. The parties must be decided. Of course, this is already we made it. The party should be resided in the India. Then only this remedy would be available. So grounds for resolution of marriage. But we have seen in the Muslim law, what are the grounds for the resolution of marriage? There are total 9 grounds are there. Can you tell me at least some of the grounds? Yes.
Cruelty, desertion,
Go ahead.
cruelty.
Only desertion enough.
Where
If a man,
about husband not known for 4 years,
okay,
to provide maintenance for 2 years,
uh-huh,
sentence of imprisonment on the husband for a period of 7 years,
uh-huh.
not
If the
performing
husband is having any contagious diseases except the leprosy,
impotence, insanity for 2 years, or leprosy, or a virulent venereal disease.
yes, renunciation of the religion. So, in Section 10 of the Indian Divorce Act contains the grounds on which a court may dissolve a marriage. So, in order to evaluate divorce, the husband or the wife must file a petition before the district court, first class magistrate court or the district court. This is basically the court under whose jurisdiction the parties solemnized their marriage or they reside or last resided together. So naturally, where you last resided together or solemnized the marriage, that place is having the jurisdiction or that court is having the jurisdiction to entertain such a case. The court may grant a divorce under any of the following grounds. Number one, when one of the parties commits adultery. Yes. If one of the spouse commits adultery, that is a ground for the dissolution of marriage. Of course, now adultery is not an offense. Adultery is not a criminal offense. Can you tell me what is the case law? Yes? I think it is a Shahani case law, Shahani versus Union of India. Okay, next B, if a party ceases to be a Christian, see, this is renunciation of the religion. If one of the parties ceases to be a Christian, that is also a best ground for the dissolution of marriage. Next, C, in case of a party being of unsound mind of 2 years, if any one of the spouse is unsound of mind for the 2 years, then it is a good ground to get the divorce or the dissolution of marriage. Then the fourth, if a party has been suffering from the leprosy, of course now it is removed. In Hindu Marriage Act, no, it is removed there. In the personal laws, yes. I'm sure that here also it is removed. All personal laws it is removed over there. Leprosy is no more a ground. Or of course, venereal diseases for the 2 years. What are the venereal diseases? Sir, typhoid, malaria, yes, diarrhea. Tell me.
Sexually transmitted diseases, sir.
What are the names? Sir, we don't know, sir.
HIV,
Gonorrhea, syphilis. These are the type of the diseases, STD, sexually transmitted diseases. Okay, number E, in case of a party willfully refusing to consummate the marriage, no BBC for the 2 years. Of course, here they did not mention the years here. But here, in case of the party willfully refusing to consummate the marriage, no BBC, that is another point. Then when a party has deserted the spouse for the 2 years or more, yes, he deserted, left it the house, not taking care of it, either physically, biologically, by any other means. So that is also a very good ground for getting that divorce. That is the dissolution of marriage. In case of a party treating the spouse with cruelty, yes, it is also a cruelty. Even not allowing to go to their wife's parents or the relatives also seems to be the cruelty. And there in the Muslim law, when I was dealing with it, I told also that a girl asked her to get married. Of course, she put the condition to get married that the husband that allow him to pay the tuition fee for the medicine. But later on, he did not pay the medicine fee. So that is a very good ground for the cruelty. Are you following me?
yes, sir.
We discussed this case law. Suppose in every
If
festival,
only if that condition is not in a paper, sir, only they agrees at the time of marriage, and after marriage he say
if any person
denounce to
making
pay.
such a thing, they will put it in writing, number one. Number two, if it is oral, at least there should be certain witnesses.
Okay,
Or
sir.
if it is a very intelligent lady would be there, she will record it also. So that he will not be go from any clutches. Isn't it? So now
Okay.
these are all the grounds would be there where we can get it. In case of a party treating the spouse with a cruelty, yes, cruelty also, I told you that what type of the cruelty would be there. So that also seems to be cruelty. Cruelty doesn't mean that only the physically the harassing, even a mentally harassing also is said to be the cruelty. So these are the grounds which we will study in the Hindu law, we studied in the Muslim law, and we studied in the Christian law also, the grounds for a dissolution of marriage. Okay. Apart from these grounds, the wife can present a petition of divorce on the additional grounds. For example, she can file for a divorce if her husband has, after marriage, been guilty of rape or bestiality. Suppose if you having any other illicit relationship with somebody else, or you in a relation with a close relatives, or the even for the animals also, if it is such a thing, yes, that is called bestiality. So that is also a good ground to get the divorce from the husband if such a thing the husband involved over there. Okay, now let us see the divorce by the mutual consent. It is the new type of the divorce has developed recently. I mean, recent times. Instead of going to the court for a long period, better you say that, see, your choice is different, my choice is different, and moreover, even after the 1 year, 2 year, 3 year, also we could not make our life thinking, our compatibility would be there, and hence better we will go for the court and take the divorce. So they mutually they will give the consent, and they will approach the court. The court also says, instead of keeping prolong this matter, better we will give the divorce so that they could lead their life in perfectly or with any other husband or single. So according to the section 10, the grounds we saw above must exist for a party to file for a divorce. That is the above grounds which I have given over there, that is grounds for the dissolution of marriage. That is nothing but divorce. And however, it may also happen that both the parties wish to seek divorce mutually. For this purpose, the Parliament amended this act and inserted section
10A.
10A.
Professor Hussein's students will not read in that way. Repeat.
Section 10, subsection A.
No. Section 10, capital A. Section 10, capital A. See, whenever the capital is added to the section, it is not a class, not a subsection. It is a additional main section only, but later on added something to it. So instead of keeping any hyphen, keeping any punctuation, they will keep like this, which I have shown. So for instance, if you really says whether I am true or not, why we have to go into the doubt? So the the Indian Divorce Act. So here I could show you the, yes. So the Indian Divorce Act, after sometimes no, they removed the Indian. And now the Divorce Act is there, 1869. After some amendment later they removed. I will tell you the which amendment they omitted it. Because some amendment they say Indian is omitted because it is going on in India, that why the Indian should be there for the Christians again. So that's why there is some logic behind it. So now what is added over there? Tell me. It is added 10A, is it not? So now let us see whether is the 10A is there or not. See here. Did you observe? Did you
Yes,
observe?
Sir.
Is there
Yes,
any
sir.
hyphen 10 and A?
No, sir.
No, sir.
But here before there was an hyphen was there here. This hyphen I removed it. This hyphen I removed it because that is the style of writing. So directly the section is added to it because earlier it was not there. So here it should not be like this, it should be like this. So 10A is inserted. That is 10A is nothing but 10A is nothing but
Insertion.
mutual
Mutual dissolution by mutual consent.
mutual consent. That is actually the we are discussing it. So 10A, dissolution of marriage by mutual consent. So that is a 10A. So now we'll see it. Yes, this according to 10A, parties may together mutually file a petition for divorce in the district court. In order to do this, they must have lived separately for 2 years and must be unable to live together. In the 2 years also, there should not be any BBC. Are you following me?
Yes, sir.
Very good. Yes, in order to do this, they must have lived separately for the 2 years and must be unable to live together. Then, in such a case, parties don't withdraw this petition between the 6 to 18 months. The court may dissolve their marriage. Another condition they said, the last resort, they say at least 6 to 18 months they will observe after filing the mutual consent.
Divorce.
So,
Mutual consent of that.
yeah, if they again represented it for several times, then the court says that better you give them, because now it's merely a waste time to reconcile them. It is a waste time to reconcile them. Better, okay, better you sanction the divorce, and they will do it also, because it's a discretion of the magistrate. There is no hard and fast rule, but only the 6 to 18 months means there may be some tensions, some of the factors and all those things. So it is very easy to give the divorce, but very difficult to get it married. Are you following me?
Yes,
Sir.
sir.
It is very easy to collapse the house, destroy the house. It is very difficult to construct the house. So they thought that, okay, but we'll give the chance. After some time they can reconcile it, because now they are young, so their blood is young. After some time the blood becomes cool, they will realize what the life. Life is nothing but a zero. But later they will realize it. Okay, now between the 6 to 18 months, it will be like that the court may dissolve their marriage. But one thing I would like to tell you, till the death, please keep your mind and brain both in a good thinking, because nobody would stop you think high. Can anybody will stop you think high? Yes?
No, sir.
No.
Nobody will stop you, because you are not committing an offense. So think high and do high and die high. That's my slogan, in one way, in another way. So,
Sir,
yes,
from 1869, there was no amendment done in this act, sir.
regarding, yes, there is some amendment is there. Yes, there are amendments should be there for this. That's the reason that 10A is added over there. Number one. Number two, even Indian also removed from the Indian Divorce Act. I will show you that when it is removed, because it is already given, because I taught last time, it is removed. When Indian is deleted from the Indian Divorce Act. How many years of the separation equal to Divorce Act now? The Indian Divorce Act, rules and regulations. Yeah, the Indian Divorce Amendment Bill 2001. What are the new rules for the divorce in India? What is the Section 10A? The Divorce Act. So that also divorce, because amendment is given here. What is the time period for the divorce in India? See, when you write what is the Section 10A Divorce Act, don't write the small a, it will be the capital A always. Indian Divorce Amendment Act 2001, I believe, or another, because the Indian is removed from there. What is the degree of divorce in India? Yeah, there is amendment. From time to time, there will be amendment will happen. See, here you have, the Indian Divorce, the Divorce Amendment Act. See, they have given so many sections, short title, this thing, that thing, and short title and the commencement. This act may be called the Indian Divorce Amendment Act. At the time, Indian is there. An omission, an amendment section 1 of the Indian Divorce Act, 4 of the 18 said here and after refer to the principal act. The word, see here, it is removed. See, this is the word Indian shall be omitted. Did you see it?
Yes, sir.
Yes, sir.
The amendment section 1, in section 1 of the Indian Divorce Act 1869, 4 of the 1869, here and after refer to the principal act, the word Indian shall be omitted. So it is omitted in the act. Which act? The Indian Divorce Amendment Act of 2001, number 51 of the 2001 amendment, the Indian is removed, deleted. Did they say omitted or deleted? What the word they used exactly? The word shall be omitted, they say. They not say deleted, they say omitted. Sir, either there is a distinction between the omitted and deleted? Yes? Deleted and omitted, is there any distinction?
Yes, sir.
Definitely there is a distinction is there. See, when there is a wrong, it can be deleted. But there is no necessity, then it can be omitted. Are you following me?
Yes, sir.
Yes, sir.
So that is the omitted and deleted. So that is the distinction between the two. And because when you are a law student, you should be very much particular regarding the words that you are using it. Even a comrade also friend, is it or not?
Yes, sir.
But if you say the comrade, please meet my comrade, what the people will think? Yes? What the people will think? Oh, this man is a socialistic and a communistic mentality person. Is it or not?
Yes, sir.
But why you
Yes,
are
sir.
not giving the question? Reply to my question. Okay. Now that is the Indian is deleted in that Amendment Act. Now let us see that nullity of marriage. How a marriage will be a nullity. Apart from the dissolution of marriage, see, nullity is different, dissolution is different. See, dissolution, because there are conditions are there, hence the marriage will become dissolution of marriage. For the nullity marriage, the beginning itself, there are certain condition did not follow it, then it will be a nullity marriage. But we read in earlier classes, if the spouse, if anyone parties, spouse is alive, and he should not go for this conducting the second marriage. When the spouse is alive, without taking the divorce. So apart from the dissolution of marriage, the Act also contains the provision of nullity. Either the husband or the wife may file a petition for this before the district court. There are a few grounds for which the party may file such a petition. So, for example, the impotency or lunacy of a party at the time of the marriage can be ground. In the beginning, that fellow is important, number one. In the beginning, it is a fellow is a lunacy. At that instance, it's more better the marriage is nullity. One can also file this petition if the other party has still married or is her spouse during the marriage. If any case would be there, doesn't matter. One can also file this petition if the other party was still married to his or former spouse or during the marriage. At any time that you can make it a thing, you can file it. So that is the provision for the nullity is concerned. Then the restitution of the conjugal right. Yes, you know the restitution of the conjugal rights, because if the husband deserted you or the wife deserted you, then you can go to the court. Sir, my wife is not coming, my husband is not coming. There is no BBC and so on and so forth. My children are not taking care of it, and children are crying over there if they do have the children, and many other factors would be there. Then they can ask the court to interfere in their matter. That is called the restitution of the conjugal rights. The Act also contains a provision for the restitution of the conjugal rights under Section 32. Sir, how could you remember the sections, sir? What is the best method, sir? At least remember a few sections, though not all the sections, especially marriage, divorce, restitution of conjugal right, lunacy, insolvency. These type of the sections, try to remember it. How do you remember it? Read, read, and read. Read, recite, and review. Are you following me?
Yes, sir.
Read, recite, review. Reading, recitation. Without looking, recitation. Then after sometimes you can give the lecture, you can review it, and you say that, oh, that's we have studied over there. So that is the best method to remember the things. So Section 32 deals about the restitution of the conjugal rights. Under these provisions, a party may seek restitution if his or her spouse withdraws from their company. The company, she withdraws any one of them, then one can approach to the court and file the petition for the restitution of the conjugal rights. Yes, under the restitution, the marriage remains, both parties don't possess all marital rights temporarily. Under the restitution, the marriage remains, but both parties don't possess all marital rights temporarily. So, when such a thing should comes over there, then one can approach to the restitution of the conjugal rights. Suppose that fellow is a very harassing, or the wife is harassing over there, then it says, sir, it is more better to be stay idle or alone rather than having such a wife or such a husband. So vice versa. So that will also be the case sometimes. Okay, now let us see that after the restitution of the conjugal rights, then we will switch on to the custody of children. Then who will be taking the custody of children? The Divorce Act contains some provisions governing the custody of children in case of the dissolution or nullity of marriage. Section 41 empowers the court to make interim order with respect to custody. Even after passing the final decree of the separation, the court may award the custody to any specific party. Now you tell me, if the girl would be there, under whose custody, up to what year? If the boy is there, under whose custody, and up to what year? Yes.
Girl under mother custody until 7 years in the Sunni law. Boy up to 2 years.
Is it 2 years or 3 years?
2, I think.
2 years, sir. 2 years.
Are you sure? Let us check whose custody would be there. In the Sunni law, when you speak about in Sunni law, in the Sunni law, boy and girl under the custody of whom? Under Sunni law, the father is entitled to the custody of the boy over 7 years. And in unmarried girl who has attained the puberty, in Shia law, the custody of the male child over 2 years, where you are right. And unmarried girl, 7 years. Yes, you are perfectly right. I don't know how I got the mind in 3 years in my mind. The custody of an illegitimate child goes to the mother. That we already studied over there. Because get the custody of child in Pakistan. Okay, this is we don't want now. Because what we got the doubt, we cleared it. Is it not? So
But sir, but this is under Indian Divorce Act, sir, for Christians. So we are saying for Muslims, sir, Shia and Sunni. Then what is the custody for Christians couple, sir?
no,
Children.
Christian also the same Muslim law would be applicable. Let us see that. What is the custody of the wife? Because it is already given in the. See, there is we just now we downloaded. Just now we downloaded the where it is gone. Just now you downloaded the. Because general rules are very common. See, what about the custody of Christian boy or girl under the Divorce Act of India? There is no law which is specifically mentioned about the child custody rights under the Christian law. According to the section 41, 42, 43, 44 of the Indian Divorce Act, of course, there is still Indian, they wrote it because the Indian is removed. The courts have the power to pass an order relating to the custody, education, and maintenance of the Christian children. So, there is no specific thing will be given, but one thing is very much clear. The best interest of the child. That is a very much important factor. See, the best interest, of course, he has given the Hanafi law and other laws are concerned. Custody of law in India. So, the best interest of the children, they say, if the father is having a good, good in the studies, good in the money, and good in the caliber, and good in the society, so the court will feel the child is more safe and more educated in the custody of the father rather than the mother, because the mothers are only casual laborers, or we can say BD workers, or we can say the Upparpani. You know Upparpani? The daily going for the building construction work. So even if such a thing would be there, then she could not afford to pay for the education and health and other conditions. So the court will feel that the best interest of the child, then they can give the custody either to the father or to the mother. So that is decided by the court. So that is the reason they said, according to the section 41, 42, 43, 44 of the Indian Divorce Act 1869, the courts have the power to pass an order relating the custody, education, and maintenance of the Christian children. So naturally, when this law is silent over there, then the suo moto or the judicial activism is there. They will come forward. They say, no, we are very, very much interested to the children, and the children should be the so-and-so custody, even though law is reverse also. A law can be reverse also. Yes, any other doubt?
No.
Shall we proceed?
Yes, sir.
Yes.
Okay. So examples on the Indian Divorce Act, of course, Indian is already removed. So it is a question, fill the following blanks. The Indian Divorce Act, the Divorce Act applies only to the members of the dash community. Which community it will be applicable?
Christian community.
It is
Christian
applicable only
community.
to the Christian community. Then the B question is, section dash allows the parties to file the divorce for the mutual consent. Which section?
Yes, sir. 10 capital A.
Yes?
Section 10 capital A.
Section 10?
Capital A.
Very good. The parties have to file the petition of divorce or judicial separation before either the first class magistrate, judicial magistrate, or the district court.
District court.
Yeah, whichever is applicable over there. Then we can see, if you happen to see, we have already downloaded at the time. See, this is the Indian Divorce Act of 1869. So here, how many sections are there total? Let us see, because this is also important factor. How many sections? Sections total 62 are there. And how many chapters? Chapters?
14, sir.
Yeah, I am showing you schedules of forms. They have given total 14 forms they have given. Here, correspondence, settlement, answer number, statement, answer number 5, and so forth. So here they have given the what way procedure should be there, and remarriage, liberty to parties to marry again. There is no question of iddat and all other things will come into the picture here. See, once the divorce is over, then next day she can go for the marriage. Yeah. The English clergymen are not compelled to do solemnize marriage of person divorced for adultery. If the person is dead adultery, they are not supposed to compel the solemnize the marriage of person divorced for the adultery. If once you divorce for the adultery, as per the moral obligations are concerned, the clergyman should not supposed to conduct the solemnize the marriage. The English minister refusing to perform ceremony to permit use of his church. Even they are not permitted to use of his church because that fellow is a debaucher and he is fully involved in the adultery. So from here, appeal to the Supreme Court also, one can go over there from the High Court. So mode of taking evidences, suits by minor, and lunatics, and custody of children. See, when you see the custody of children, we can say 41, 42, 43, 44, it is given over there. They say power to make such orders after a decree, powers to make orders as the custody of children to suits for the dissolution of or nullity, or powers to make such orders after decree or confirmation. They say, but up to the age of here, up to the age of there, it is not specifically mentioned. Is it clear?
Yes, sir.
So here the word they say omitted, they did not say deleted. See, whenever you say that they say omitted, 34, 35, they are omitted. Can you tell me what is alimony?
Bharanam. Maintenance Bharanam, sir.
A lump sum money which is given over there is said to be the alimony. Once alimony is accepted by the divorced wife, again she cannot file a case in the court of law for the maintenance. Because I don't know whether you saw or not today that in the WhatsApp group has come over there. They said we can apply for the maintenance under the Hindu Marriage Act of Section 25. We can also file a case for the maintenance under the CRPC 125. Then in other domestic violences act also there, we can file a case for the maintenance. So there is no hard and fast rule would be there. You should file a case under so and so act only. Even though Hindu Marriage Act has given the decree of the divorce. And alimony, which is not accepted by the other party, at that instance, till the case is decided in the court of law, I mean Supreme Court, up to, then till the case is decided, up to that extent the maintenance should be given by the divorced husband to the divorced
Wife.
wife. And today it came in the Google search engine that when I found, I read the total case law. Then it is given, yes, when the case is still pending in the Supreme Court regarding the divorce and alimony is not accepted by the wife, at that instance, she is entitled to get the maintenance. You check it. If I find no, I will post you in your group, because the morning only I read that case law. So this is about the, now the Indian is removed over there, then it is merely a divorce act. You are not giving the answer to my questions. So
Yeah.
desktop, then this is the, if you see the syllabus, next is, where the syllabus? Yeah, it is here. So if you happen to see the syllabus, the salient feature of the Divorce Act 1869 we completed, then we will see what are the matrimonial remedies and the Divorce Act. This we'll study tomorrow class. What are the matrimonial remedies? Now you tell me, what is matrimonial remedy? You will think it. You read it, then you come to the class, then we'll discuss this. So with this, I would like to stop my today's lecture. Then thank you very much for patient listening, and I see you tomorrow at the same timings. Now the end of the meeting.